We are in the room of the mighty Reno High School, aren't we? How wonderful to see so many parents here. Give yourselves a round of applause.
All right, if you'll be seated, please. I'm David Hardy. I am a district court judge in Washoe County in the 2nd Judicial District Court. I'm joined by Judith Simpson, who has been a civic education specialist for many years. She has devoted her professional life to this work. Seated next to Judith Simpson is Chief Judge Scott Pearson of the Reno Township Justice Court. And then at the end is Rachel Anderson, who is a professor of law at Boyd Law School. We are here for Unit 1, and I will ask the following question. Why did the founders believe that a constitution should function as a type of higher law? In what important ways does a higher law differ from a statute enacted by a legislature? Evaluate the founders' claim that direct democracy was more likely to ignore constitutional limits than representative government. What evidence, historical and contemporary, can you offer in support of your position? And with that, you may begin.
During North Carolina's ratification convention, Samuel Johnson argued, every usurpation or law repugnant to the Constitution cannot have been made in pursuance of its powers. The founders believed that if higher law was not defined by a Constitution creating a representative democracy, the people would have an undue influence over higher law as an indirect democracy.
Due to the malleability of British uncodified laws, the founders believed in a written constitution that would protect universal principles of higher law, such as fairness, justice, and morality. Because this constitution strives to protect these principles, Article 6, Section 2 describes it as the supreme law of the land, thus providing a system for legal higher law.
The amendment process of Article 5 exhibits fairness by providing a means for states and posterity to have a say in the application of the Constitution. Justice is upheld by Article 1, Section 5, allowing for Congress members to be expelled in accordance to rule of law. Furthermore, morality derives from the interpretation of judicial review in Article 3, Section 1. When Justice Greer cited in Schindler v. Shivo that everyone has a fundamental right to the sole control of his or her person, he modified the community standard for morality.
Higher law differs from statutory law in that higher law establishes individuals' basic rights, limits the government in its influence over those rights, and can only be changed through consent of the governed by established procedures, whereas statutory law derives from and is subject to higher law. While Article 1, Section 9 maintains that Congress cannot abridge the right to habeas corpus except in justified cases, the Military Commissions Act held that it could be suspended for Guantanamo prisoners. Ultimately, Boumediene v. Bush declared this unconstitutional.
Through the initiative process, California administered Proposition 8 on their 2008 initiative ballot, a direct overturning of the interracial marriage cases. 2 years later, the Northern California Federal District Court deemed it unconstitutional in Perry v. Schwarzenegger. Historically, the Revenue Act of 1894 sought to impose a direct tax without regard to a census, and was overturned by the decision in Pollock v. Farmers Loan and Trust due to its violation of Article 1, Section 9. The 16th Amendment, however, invalidated this, and statutory law became higher law through consent of the governed.
The founders believed that direct democracy would ignore the Constitution because without the responsibility given to elected representatives, mob rule would extenuate constitutional limits. In Federalist 78, Alexander Hamilton argued that without a solid judiciary, the people themselves could occasion dangerous innovations in government and serious oppressions of the minor party in the community. In Athens, democratically run trials were unbound by good behavior, had jurors numbering into the thousands without a presiding judge, and could even make death penalty decisions without confirmed evidence.
Since the Progressive Era, 24 states, through the initiative, referendum, and recall methods, have given citizens the opportunity to participate in a form of direct democracy. Despite this transition, direct citizen participation can hinder the function of government due to lack of knowledge of issues at hand. Nevada continues to lack an appellate court because voters are not aware of its necessity, evoking the idea justice delayed is justice denied.
In his work, Discourses Concerning Government, Algernon Sidney wrote that governments that are well constituted place arbitrary power so as it may be beneficial to the people, and set such rules that are hardly to be transgressed. Only in a representative government could the people delegate their trust so that higher law can continue to be achieved. Thank you.
All right, we now turn to the next phase of the competition, and I invite Ms. Simpson to begin.
Unit 1 is, to me, like a rubber band. We have one view on one side, then it stretches over to the other one, right? Both with individual rights, common good, majority, minority. I want you to place on this rubber band your beliefs of the NSA and what it's doing about your information.
Quite honestly, I see the NSA as something that is good for America. It was established with the Patriot Act under the George Bush administration, and it basically established that all information would be saved into metadata in private institutions, and it protects the common good of the nation by ensuring that international terrorists or another country isn't invading our own privacy as well as plotting a terrorist attack.
On the other side of the issue, the NSA has completely disregarded American citizens' rights to privacy by collecting data on their communications. And as Edward Snowden revealed in his leaks, it has also hurt our ties with our allies, such as Germany, by our spying on the German Prime Minister. And so the NSA, the current NSA's actions have gone against what it was originally designed to do and turn it against the American people.
In contrast with Elise's point, I'd like to point that the NSA is providing a way for America to show classical republicanism, which is very deficit in our Constitution, by providing protection for all citizens.
What are your opinions? That's what I'm trying to get at. What do you believe in?
Well, I believe from what my last answer was that it provides a way for the community to be as one and to sacrifice their rights for the good of the nation.
I believe that people's rights to privacy should be upheld. That's why there's such an issue of drones invading on people's privacy right now. That's why Amendment 4 of the Constitution has penumbras that allow us to interpret privacy from that. It is a constitutional right, and we absolutely have to have that upheld.
I myself believe it's good for us. It keeps us safe. I don't have any emails on my computer that say illicit things about the government or me wanting to do a shooting at a school, but other people do. And if it comes to me being harmed because the NSA gets shut down because people think their natural rights are being infringed, I'd rather have the NSA stay open to keep our cities safe and to keep terrorists out of our country.
I would like to agree with Elise. The Fourth Amendment protects us against search and seizure, and it needs to be changed to include modern day properties such as emails, cell phone text, cell phone, phone calls.
What is the relationship between a constitutional government and a limited government, and how can we determine when and if the government is overstepping its limits? And maybe you can use something from modern examples, could be related to healthcare or to voting rights, but it could be something else.
Well, by definition, a constitutional government, by definition, a constitution is something that sets a structure. And so a constitutional government is limited by the structure of their constitution.
The Magna Carta created this idea in 1215 England by setting up structures that would allow the barons to check themselves and allow them to check the king, which is the very start of limited government, specifically in Articles 61 and 63 of the Magna Carta. This is carried into America in historical examples such as when President Truman tried to take over the steel industry during the Korean War and was ruled against by the Supreme Court, saying that he was overstepping his powers and denying the principles of limited government.
Internationally today, you can see the current issue with Ukraine, where hundreds of thousands of Ukrainian citizens have been going in protest because they believe their government has stepped over their power by dismissing the EU's proposal to becoming a part of the European Union. And the people were all for it, but the president himself believed that Russia, being closely related to Russia instead of the EU, would better affect their economy.
Furthermore, separation of powers is inherent to having a limited government. The Supreme Court is now judging whether President Obama's recent appointments were actually constitutional or not.
Questions?
Yes. I'd like to very briefly ask you about whether it matters, and then I have a better follow-up question. Does it matter that a constitution is written or unwritten?
A written constitution is an easier and more effective way for a government to be set up. In England's unwritten constitution, William Blackstone actually had to gather all the common law, statutes, and documents together to create a cohesive constitution for Britain. Our constitution is in one document, and it is the higher law for our country, from which every statute and court decision has to be derived.
I would actually like to disagree with Elise. I believe even our Constitution has its own unwritten Constitution. There are many judicial precedences involved in our Constitution that aren't listed in the amendments or aren't listed in the articles of the actual Constitution. There's also this philosophical Constitution that we go off of. Our beliefs fit into the Constitution and shape it every single day.
The amendments of our Constitution are supposed to change with the social changes of our society, but we haven't passed a new amendment in years. And the 27th Amendment, which was the last amendment passed, it wasn't ratified for 200 years.
All right, unless my colleagues object, I'd like to ask you about marijuana. Specifically, whether it's by referendum or proposition or through their state legislatures, what happened in Colorado and Washington, and how that conflicts with the United States Code, and then our chief executive officer's decision not to enforce as his obligation as the executive branch the United States Code against those states. Would you discuss any as that relates to these issues?
Both in Colorado and Washington, their legalization of recreational marijuana was done by initiative, showing that the people support more than they have before in past years the idea of recreational marijuana. However, it does go against the federal government, and some states are worried that it can encroach on their own rules. For example, a Nebraska senator said that he was afraid that marijuana use from Colorado would transfer into his state, and he was worried that because he said we're not fighting a war and it's not like you can put police on the borders, so he was worried that there would be no way unless the federal government steps in to limit the distribution in other states of that marijuana.
Continuing off of Elise, the federal government actually did provide a lot of funding for when Colorado and Washington did legalize marijuana to train the police officers and to train the judicial system in order to counteract anything such as interstate commerce of marijuana going to those states around the legalized zone, and to show the police officers the signs of what may be legal or illegal.
Justice Louis Brandeis also argued that states are supposed to act as laboratories of democracy. They're supposed to try new things so the federal government doesn't try to enact something that's not going to work.
So if law is law, is it okay to violate lower laws in pursuit of higher lawful principles? For example, civil rights activists, can they violate jaywalking ordinances, things of that nature to serve larger principles? Where are what's acceptable and where are the lines?
Mahatma Gandhi said that only when citizens have shown their loyalty to their nation by upholding that nation's laws do they gain the right of civil disobedience. And so he would argue that citizens must uphold laws derived from higher law before they can disobey any other law.
In his open letter, letter from a Birmingham jail, Martin Luther King wrote that freedom isn't freely given by the oppressor. It must be demanded by the oppressed. And so our Constitution allows for us to break, I'll reiterate that point. So by having a social revolution, as we did with the civil rights movement, our country becomes a better country because we as individuals are asserting ourselves in our nation.
Philosopher Rousseau, in his Social Contract, also said that as long as someone isn't infringing upon someone else's rights, they can break the rules.
Our nation was founded off of civil disobedience and civil discourse. And I believe that these acts, such as the civil rights movement and the women's rights movement earlier than that, are acts of civil discourse where the government, where the people are giving these redress of grievances to their government to fight legislation or amendments they think are wrong and to change the government, because in the United States they have that right to change it.
Okay, so Rousseau said it, but does it apply today?
It does apply today because in the amendments, in 8 of the amendments, Congress has enforcement clauses that allow them to continue to enact statutes that uphold those amendments no matter what the time period. That's why the Civil Rights Act of 1964 was able to be passed, and that continues to help Congress make legislation today.
I'm concerned. What we're talking about. Oh,
Yeah, you can ask your question.
I'm concerned that our government isn't functioning the way we should be having it function now, whether it's a written constitution, unwritten constitution, anything. Our founders would be having heart attacks over what's going on in Washington, wouldn't they?
Yes, they would.
Is there anything besides voting that we could do to make this a better functioning government?
Well, in Federalist 10, James Madison and Alexander Hamilton warned against the large groups of factions, and they believed that such things as political parties would be a hindrance.
So this is really hard for me because Judy Simpson is the matriarch of the program. But if we let you continue, then it's unfair for us to stop.
I said what I had to say.
Because after all, a higher law is fairness, right? All right, who wants to go first? Anybody have thoughts springing to
I
mind?
will. I love the way you started it. I thought that with your fairness, justice, and morality, and then applying that throughout that whole 4 minutes was brilliant. I also liked that you came up with examples that we haven't heard before, which is, you're the last class, that's refreshing for us. But you have had so much fun doing this together, it's obvious. And I can see that you've had a lot of disagreements. But that you've learned how to work these through and talk about them with civil discourse. And that's what this whole program is about. It's a privilege to be in this room with you, and it's a privilege to know your teacher.
Thank you.
Thank you.
Great job. So there were several things. I'm going to highlight some things I thought were particularly unique or sophisticated. One of the things I liked in your initial presentation was you were talking about direct participation, and you said that one of the issues with direct democracy and direct participation was a lack of knowledge. And I thought that that was a really interesting point to bring up, because we see this issue of a lack of knowledge playing out in all kinds of statutes in other areas of the law, not just at the federal level, but really how do you make sure that people have enough information to make informed decisions and participate directly. So I thought that was a really important point to bring up. I also liked, in response to, well, it was my question, I suppose, but in terms of how we know when the government is limited or exceeding its limits, that you talked both about the separation of powers and then the role of the courts within the separation of powers, so that we have this system built in that helps us know when the government exceeds its limits or not. But then you also gave the example of people protesting in Ukraine, right? You could have given an example here as well, so that we also see this form of direct democracy through protest, that the people tell the government directly also when the government may be exceeding its limitations. And so I thought giving us both our formal structure as well as the actual people then being involved in the government was a great way to address that. And I particularly noted, I was impressed that you brought Truman in the steel industry case into that. That's not always the one that's cited for that, so I was impressed by that. And then I also thought that as you turned the discussion a little bit later on, you started with Justice Brandeis and moved to the states are laboratories for democracy, and you had some questions about whether or not you can violate law, and which law are you serving, and when may you. Your answers to that were really sophisticated. So not only did you cite back to some of the leading activists that people might talk about, you gave us Justice Brandeis as well, but you also said, here's a context. You may do this, but only if you meet the requirement of being a citizen, of fulfilling certain duties, and even then only in certain contexts. So although you opened the door to that space, you also limited it specifically, and I know you also talked about Rousseau and the social contract in that context. And that's a really difficult issue to pick up, right? When, law and violating or not. And bringing in specifically the term of civil disobedience, I think you added in then a sophisticated way of addressing that, because it wasn't just violating laws randomly, but rather specific context, and you even set it into the movements of the women's rights movements and the civil rights movements. So you located it also historically, which I thought was really well done.
So we're 20 minutes behind.
It's all right.
I think the genius of this program and for successful teams is that you first identify the concepts, you study them, and you learn them, and then you push them through some filter of analysis that's made possible by the group process, by the coaches, the teacher, and then from that filter of analysis, you'll arrive at your opinion. And I think you need to show all three of those phases in your presentation, and I saw that today, and I just can't tell you how I felt when I heard you make reference to out of ordinary supporting authorities. Your reference to the Birmingham jail, for example, is not something that I would have seen. It's not something I've heard. And references to the Fourth Amendment search and seizure right after the NSA, that's not something you could have really predicted from us. And it reveals the depth of your preparation and your understanding, and well done. I really appreciate it.